Let's discuss one of the biggest myths that rookie private investigators and many other people fall for regarding criminal defense cases. That big myth we are discussing right now is what I refer to as the failure to Mirandize myth. Many people, including PIs, think that just because the police never read them their rights, they are off the hook. Well, I am here to tell you folks, nothing can be further from the truth than this myth. Now first, let me be completely clear. I am not an attorney, nor do I play one on YouTube or TV or anywhere else for that matter. This is not to be considered as legal advice. Rather, it is just my opinion. If you need legal advice, please seek that from an attorney that specializes in the area where you need legal advice. Yes, if you are arrested, the police do need to Mirandize you, but they do not have to Mirandize you immediately upon arrest. This is a key misconception that people have. It does not go like TV shows and movies depict. Sir, please place your hands behind your back. You are under arrest. And then, as they are slapping the cuffs on you, they start the Miranda process. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to have an attorney present during questioning. If you cannot afford an attorney, one will be appointed for you. Do you understand these rights as they have been read to you? This video is sponsored by OREP Insurance and Working PI Magazine. OREP is a leading provider of private investigator liability insurance. Visit orep.org for a quote today. Now keep in mind there are many variations to the Miranda warnings out there. Many police departments have adopted their own language to cover their jurisdiction's rules and regulations, which can vary from one state to another as well from city to city. But the fact that they didn't read you your rights immediately before arresting you does not get the case automatically thrown out of court. In fact, many times the police may detain a suspect before they arrest them. And anything the suspect says during the detaining period is not necessarily subject to the protections of their Miranda rights, as the subject is not under arrest yet. Now, to be sure, many times anything a defendant says to the police before arrest can be safeguarded against being used to incriminate themselves, sort of. It gets pretty complicated, but I think it is safe to say that anyone who finds themselves under the scrutiny of law enforcement would be better off just pleading the fifth and asking to have an attorney present when the police start asking questions. The bottom line is that the Miranda warning must be given to individuals before questioning them while in custody. Key words, while in custody, or for all intents and purposes, while under arrest. One major tactic law enforcement does is detain someone and lets them know they are not under arrest. They are just being detained, and then they start asking questions. In fact, this questioning often begins long before they even detain the suspect. This is part of their investigation. This is how they gather information to find evidence. They may not make direct accusations during these questionings, like, "Where did you throw the gun that was used in the robbery?" They may make a statement and ask a question like this: "The bank teller told me you were there cashing a check right before the robbery. Where did you go after you left the bank?" Now, they are not asking you if you robbed the bank or attempted to rob the bank, or even if you were involved in any way in robbing the bank. They are attempting to gain information on several levels here. First, do you immediately defend yourself about the allegations, even though there was no allegation? Many guilty people will immediately defend themselves early in the process. It is just human nature to do this, and this is what we call a tell in the investigative world. It doesn't mean that person is guilty, but it often leads an investigator to believe they may be trying to deceive them with a sudden declaration of innocence. They're also trying to find the smoking gun or other physical evidence that the subject was involved. Thus, they may want to know where you went after you left the bank. They can then backtrack those steps and see what other evidence or witnesses they can find. And they want to have what you say documented. So later, if they ask you the same thing, they want to see if you change your story. Many times, if someone is being deceptive, lying, or even if they're very nervous, they will tell differing stories. Like first, saying, I left the bank, walked down to Fifth Street, and then I went home. Then later saying, I left the bank, walked down to Fifth Street, then was heading home, and a buddy stopped and we drove around for a minute, then I went home. Both of these statements could be considered accurate. The first statement just left out the buddy picking him up and driving around part by mistake. But it could be because he remembered. The neighbor saw his buddy drop him off, so he had better tell them this to make sure that he had all of his bases covered and make sure that it looks to be on the up and up. This gives the police more information to go find more witnesses and evidence. They usually will not just ask you flat out if you robbed the bank, stole the car, or took the candy from the candy store until after they have Mirandized you. Because if you answer it after being read your rights, it can be used against you in a court of law. If they just pull you over and ask, did you just rob the bank? And you say, yeah, what are you going to do about it? Well, yes, they may arrest you on the spot. But they probably cannot use that confession of guilt against you to prove you did it. As well, they probably lost any other chance to gather other intel and information that could lead them to more evidence. That is why they start off with questions like, do you know anything about? Did you see or hear anything over there? Have you heard anyone say anything about this? And other leading questions that they use to try to gather information. One of the big things about Miranda Rights is that you have the right to remain silent, but most people do not realize this. You have the right to remain silent even if you have not been read your rights. At least in this country, the good old United States of America, you have those rights. You can always plead the fifth or just refuse to talk to the police, but I would say that it is usually best to just say, I have nothing further to talk to you about without my attorney present. And if they persist, which they shouldn't, but if they do, just keep saying you want an attorney and nothing else. Stay calm, stay in control, stick to your guns and saying you want to talk to your attorney. Once you are Mirandized, though, there is the fact that anything you say can and will be used against you in a court of law. This is self-explanatory. This is the big warning that explains that anything you say during the interrogation may be used as evidence against you in a courtroom. And trust me, it will be used against you in a courtroom. Then there is the part of the Miranda warning, you have the right to have an attorney present. This statement informs the individual that they have options to consult with an attorney before answering questions or making statements. And it is often followed with, if you cannot afford an attorney, one will be appointed for you. So if the individual is unable to hire their own lawyer, a public defender will be assigned to represent them. But that does not guarantee anyone an attorney. That is the big myth about this section of the Miranda Rights. Most people think this guarantees everyone an attorney. You may be broke, but you still fall within the monetary guidelines of being able to afford an attorney due to your income or other assets that you have. Thus, you will not get a court-appointed defense attorney or a public defender. The bottom line is that you have the right to have an attorney, but there is no guarantee to have one appointed to every defendant. It all depends on each person's specific situation. Now make sure you're clear about all of these myths regarding the Miranda Rights. It is so easy for just about anyone to fall into the trap of believing these myths and not discovering the truth before it is too late. My biggest advice to all my clients regarding any criminal matters is to simply not talk to the police at any stage except to request an attorney. The police always use the ploy of, well, if you didn't do anything wrong, then there shouldn't be anything to worry about or to hide from us, right? And this is designed to make you feel uncomfortable, make you feel like if you don't answer their questions, they will automatically think you are guilty. But the truth be known, they already do think you did something wrong. So just protect yourself and respectfully decline to answer questions without your attorney present.